If you were arrested for the first time, you are probably scared, confused, wondering what is going to happen next. This is probably the thing that is keeping you up at night right now. So in this video, I'm going to be going through 5 things that you should know if this was your first time being arrested, so that you have a better idea of what to expect and how to handle things going forward. My name is Veronica. I'm a criminal defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. Okay, so let's jump right in. 5 of the most important things that you need to know about this whole criminal process if this was your first time being arrested. Number 1, if you were arrested and you bonded out, or maybe you were released OR, which means that you didn't have to actually pay anything to get out of jail. You got maybe a slip of paper and you were told to go on your way. Nobody probably explained anything to you. What you may not realize is that as of this moment, very likely, if you haven't been to court yet, no charges have actually been filed against you. I know that sounds really weird because maybe you had to pay money to get out of jail, you went to jail in the first place, you're told, hey, here are the charges. But the thing is, when you get arrested and you bond out, before your first court date, a prosecutor, a lawyer, actually has to look at the police report, look at your criminal record, look at anything else that an attorney may submit on your behalf, hopefully good things about you, hardships you've experienced, letters of recommendation, maybe your side of the story, and make a decision as to whether they actually want to file charges. So there's a chance that they will decide not to do that. Now, obviously, you want to do everything you can to get them to drop the whole thing. I mean, imagine if you can hear before your first court date, hey, charges have been dropped, you're good to go. You don't even have to come to court. That would obviously be best case scenario for you, right? So what I do recommend for people, obviously I'm a criminal defense attorney, is if it is possible for you, and I know it's not for everyone, hire a criminal defense attorney before court to talk to the DA, to submit the good things about you to the DA, so that when they are making a decision as to whether they're going to file this thing and whether they're going to file it as a felony, as a misdemeanor, whatever it may be, they have as much positive information about you as they possibly can, because you know that if you get arrested, whatever's in the police report is not going to be good for you, right? So you don't want them making the decision just based on that. Now, in your favor, you have the fact that you don't have criminal history, because they will know that too. But there's always a first time for everything, right? And you don't want to end up with criminal history. Number 2, it doesn't really matter if the victim wants to press charges or not. I know if you watch Law and Order, or, I mean, maybe if you just have common sense about how things maybe should work, you think, okay, the alleged victim, maybe my family member, right? Girlfriend, boyfriend, does not want to press charges against me, doesn't want this case to go forward, it should be dropped. Right? Even if they did want it to go forward at first, it should be able to be dropped if they don't want it. So that is actually not at all how it works, at least in the state of California. How it works is that once the police come out and they decide to make an arrest, the case does not belong to the victim anymore. In fact, you'll see if charges actually are ever filed against you, the name of the case will be the people of the state of California versus your name. Now, hopefully it never gets to that, but it is actually the prosecution that is going forward with this case, whether you want this or not. Now, I primarily work on domestic violence cases, so I have a lot of situations where it's the wife, it's the girlfriend who's calling me and saying, I want these charges dropped. I never wanted this to go forward. You know, maybe when the police came out in the first place, I didn't even tell them anything happened, but they just decided to arrest him. That's so common. Obviously, if they're calling private defense attorneys trying to hire one to help out, they want nothing more than to have the whole thing drop, but it's not that simple. Now, it definitely helps if we have the victim on our side. So one thing that I will sometimes do, and by the way, victim is a legal term for the person who the people of the state of California say that you committed a crime against. So when I'm saying that word, you may be thinking, but there is no victim here. But I'm going to use that word because I'm used to using it as an attorney. And if you hear that word in court, just know that that's the word that people in court, that the lawyers, that the judges, that everybody uses to refer to the person who they're saying that you committed a crime against. So what I will do sometimes is I will have the victim write up a statement about their side of the story. And when I'm submitting all the good things about my client to the DA, I make sure to include that in there. Because a victim calling the detective and saying, hey, I want to drop charges, or even going to the police station and saying, hey, I want to file another report, a supplemental report talking about how I want to drop charges. The DA doesn't always necessarily see that because the cops aren't really on your side and they're not really on the victim's side either. But if you hire an attorney who is contacting the DA for you, that's their job to try to get the case dropped before court if possible, then that person is going to make sure that it gets into the DA's file. The other way it helps to have the victim on our side is what can be really bad is if the alleged victim is contacting the DA and saying, I want these charges pressed. I want a 10-year protective order. If they're getting pressure from the alleged victim in a case, they are potentially more likely to file it. It also helps, of course, if the case is ever going to get to trial, if they know, hey, okay, the alleged victim does not want to press charges. If I put him or her on the stand, it may not go that well for me as the DA. They may be more likely to give a better deal or eventually potentially drop the case altogether, or ideally not even file it. Number 3, what is going to happen at the first court date? First of all, you're going to find out, if you haven't found out already, whether charges have been filed against you. And the way that you're going to find that out in the state of California is usually that there's going to be a list. In most counties, it's going to be on some computer monitors when you come into the courthouse. There's going to be a list of everybody who has charges filed against them. And if your name isn't on there, you then have to follow the instructions of the court, but go to the clerk's office or go to, sometimes they tell you to go to a particular courtroom, or wait in a really long line and find out if charges have been filed against you. And sometimes you'll have to wait around for a few hours because the DA hasn't decided that yet, and they're looking at the case that same morning. So that is number 1, and I know that that's really unexpected to a lot of people. And actually, when I first became an attorney, I thought that was crazy. Like, hey, you guys told us we had to be here at 8:30. My client will have a warrant if they don't show up, but you're telling me you haven't even looked at the case yet. But that's how it works. So that's the first thing. Let's say that they have filed charges, or you're told to go to a courtroom. In court, all that's going to happen is that your attorney, and if you don't have an attorney, then you'll get a public defender, and each courtroom has a different process for that. You fill out financial paperwork sometimes. Your attorney will get a copy of the police report, will get a copy of exactly what the charges were. So for some types of cases, like PC 273.5A, that's domestic violence, it could be a felony or a misdemeanor, you'll find out, okay, if they filed it, did they file it as a felony or as a misdemeanor? And there are many other charges like that. Your attorney will also usually get a copy of that police report, then give you a better idea of what the allegations actually are. Now, you'll probably wait around some more, and then eventually your case will be called. You'll hear your name, you'll have to stand up next to your lawyer, and your attorney will enter a plea of not guilty and get another court date. Now, if this is a domestic violence case, then the DA will generally ask for there to be a restraining order prohibiting you from contacting the alleged victim. If the alleged victim is on your side and doesn't want this, then the alleged victim will have a chance to speak to the judge and explain why they don't want a restraining order. And while you're in front of the judge, there will be another court date assigned. Now, what didn't you hear in there? What doesn't go on is there's not going to be a chance to get the charges dismissed if they've already been filed that day in front of the judge. There's not going to be a trial. There are not going to be witnesses who sit up on the stand and each attorney asks them questions. It will probably be pretty simple and most of all, pretty boring. It's not anything to feel scared about or feel like this is going to be a really, really big day. Of course, you may be finding out if they filed charges or not, and you may be finding out what level of charges, felony or misdemeanor. But overall, what's going to happen in court is that there are going to be probably 20 to 50 people that are going in front of the judge for like 30 seconds, and that's it. Number 4, how court works. Okay, so I just told you that at the first court date, a whole lot of nothing happens, and you get another court date. Now, you may be wondering, well, is that going to be the trial, or what's going to happen there? Typically, what is going to happen is that after the first court date, your attorney is going to read the police report. You're going to read the police report too. Maybe you're going to talk to your attorney about the police report. Your attorney might, if they haven't already, start sending you to some classes that you can start doing. Or if they haven't already, maybe have you get some character letters together. What they're going to be looking for on the police report is, are there any motions I can file to get the case thrown out? For example, maybe the only evidence against you is a confession that you made, but they didn't read you your rights. Okay, so now they have to file a motion to get the case thrown out. There are many different types of motions that maybe they filed. They also have to look through that report and see, okay, is there more discovery? Are there more items that I should have that I don't have? Maybe the 911 call is significant and I don't have a copy of that, or there's surveillance video or witness statements that I don't have yet. They need to request that from the prosecution. And that, unfortunately, is an ongoing process. You would hope that they would turn over every piece of evidence that they have involving your case if they're going to file it against you, right? You had to maybe pay money, get out of jail, you had to show up to court, they're filing these charges against you, maybe even against the victim's wishes. You'd think that they would just have, here's the entire box of evidence, but that's not really how it works. It does take some time, and your attorney has to make sure that they get everything in your case that they need to properly evaluate it. Now, going back to the next court dates. So how this works for the court basically is, okay, the case gets opened, and then the DA and the defense attorney do some things, and eventually the case is either going to get set for trial, or there's some sort of a plea deal. Maybe the DA realizes that there's not enough evidence and dismisses it. I mean, there's a whole range of possibilities here. There's some negotiations going on. And so eventually there's some sort of resolution there, or the case is going to get set for trial. Now, from the court's perspective, the judge's perspective, they're not involved in every single thing that's happening there, right? They're not involved necessarily in your attorney emailing the DA saying, hey, there was surveillance video, I still don't have it, I need that, can you get it to me? They're not involved in your attorney submitting character letters about you and proof of your classes necessarily. But what the court wants to do is make sure that the case is on track and that it's moving along. And so they will set what I typically explain to my clients as check-in dates. So approximately every 30 to 60 days, there will be a court date where the judge is basically asking, okay, what's the status? What's going on with the case? Because the judge wants to make sure that, that the case doesn't get forgotten about, and that the docket doesn't pile up so much that instead of 20 to 50 people going in front of the judge for, 30 seconds to a minute, instead now there's 200 people. So the judge wants to put some pressure to make sure everyone keeps the case rolling along. Now, especially in really busy counties for the defense, what we want to use these court dates for is to make sure that we get whatever we need from the DA. The DAs are in court pretty much all day, and they sometimes will not necessarily respond to their emails right away or really even look at the case unless there's a court date. So if you push the case, let's say 120 days out, the DA may do absolutely nothing until 120 days later. So basically, I think of these court dates, these check-in dates, unless there's a motion or something like that, as an opportunity to meet with the DA about the case. And you'll see in court that that is what defense attorneys are typically using the court date for. They are all sitting, waiting their turn to talk to the DA, saying, hey, I'm here on this case. This is what I've been asking for. I emailed you. Did you see it? I need this information. Or I submitted these character letters. Would you consider dismissing the case in exchange for classes? Or, just talking to them and negotiating with them about the case. So I know a lot of people can feel stressed out about each court date. You typically as a defendant are going to have to be there, and you dress up, you're anxious about this, you're missing work for it, and then you go and you're like, that was a whole lot of nothing. And that will be how most court dates are, unless there's actually a motion or unless there's a trial or a preliminary hearing where there are witnesses that your attorney's cross-examining. Pretty much it's just going to be these dates for the meeting, and you'll sit there for a long time and it will be really boring, and then you'll go in front of the judge for, a minute, and that will be it, and get another date. Number 5, and maybe I should have made this number 1 because I think that this might be the biggest question. Am I going to jail or prison? Okay, so I'm just going to be speaking very generally here, and there are no guarantees, there are no promises, especially if you're not even my client, but we can't make guarantees or promises in criminal law. In general, if your bail was $50,000 or lower, and it is your first time being arrested, in my experience, typically, you will not do jail or prison time. Now, what am I basing that on? So $50,000 is the typical low-level felony bail. And if it's your very first time being arrested and your bail is $50,000, you probably were charged with a wobbler, something that could be a felony or a misdemeanor. And so that's something that in general, if it's your first time being arrested, we can get reduced to a misdemeanor at minimum. And then typically, And I'm not saying the very first offer we get from the DA, but typically, eventually, we can get an offer that includes no jail or no prison time. Obviously, every case is different. And I'm not telling you that if your bail is $100,000 that you are going to do jail or prison time. That's not true either. But in general, $50,000 or less, first time, probably not. It doesn't mean don't take your case seriously. And I'm saying the eventual result after putting in work in the case, after showing the DA that you're not just going to take the very first offer, after going through the police report, seeing if there are any motions, after following your attorney's advice, with getting character letters together, with going to whatever classes they're going to recommend and send you to, probably that is going to be the results. And I'm just going to give a quick bonus because actually while I was filming this, I got a text from a client who was asking me about, we did get their charges dropped before court, and they're asking me about bail being refunded. Okay, if you paid a bail bondsman a certain fee, so if your bail was $50,000, maybe you paid the bail bondsman $4,000 or $5,000, you typically will not get that money back from the bail bondsman. I don't know of any bail bondsman who will give you a refund on that. I mean, you can check, it might be in your contract, but typically you will not get that back because that is the fee to the bail bondsman. The bail bondsman gets their money back from the court, and they actually had to post the whole $50,000. But that fee, the $4,000 to $5,000 that you spent if your bail is $50K, that's the fee for having the bail bondsman go and do that. The risk of them putting up the money, that's the fee that they charge. So no, you don't get that back. If you put up your own $50,000, you will get the entire thing back though. I hope that this video helped. If you do have a criminal case in California, feel free to give me a call. You can find my number down below. You can also book a consultation there. And if you did find it helpful, please don't forget to like, subscribe, and ring the bell.